Chair, and thank you, Ms Clegg and Professor Craven. And I also noticed, Professor Toomey, you're in the audience. It might save some of the questions that come later. I'd like to focus in particular on the risk of the voice to the executive that you've raised, Professor Craven. I'll primarily direct my questions to you, but Ms Clegg, I'd be interested in your views at the end of it. I'd like to narrow the risk because we are short on time. We only have these 5 days and there's other areas and matters to go across. And can I thank Professor Toomey for your submission that's helped narrow the focus on how we assess that risk. And in looking at the risk, we have a few tasks. One is to assess it, that it exists. And then number two, to hear your opinions about how we quantify that. And it seems to be there's varying opinions about whether it's low or higher. And then the third task may be that how do you fix it? How do you address it? So that's what I'd like to focus on. So if I could start with you, Professor Craven, I think it would be instructive if you could articulate the risks that you see in the voice to the executive, particularly in terms of the obligation to consult and delay.
Yes, I mean, you really begin with the history of the thing. The idea of the voice was to try and bring Conservatives on board to get a bipartisan referendum. The thing that absolutely activates Conservatives on constitutions, and our constitution, is the possibility of judicial review leading to judicial activism. The fundamental problem with the phrase executive government, in my view, and there are different views on this, is that it will allow the judicial intervention into that provision. So to take if you forget about a constitution and you just think of it as an ordinary matter of statutory interpretation, that something may make representations to something else, I think the logic of that is that you can't prevent them, you've got to give them enough time, you've got to facilitate that representation in the sense of giving notice, and you probably have to take account of it, which is not mean to agree with it, but it is at least to plug it in. And the result of that, I think, is at the very least, there's a very significant problem that judicial activity will delay, possibly very, very considerably, the taking of executive decisions. I note Mr Justice Haynes' view that delay is not a problem. I think delay is often a problem in government. If you've got a very important decision that you want to make, you need to make it within a time frame. And realistically, if you extend this out, you run the problem of, well, what happens if the voice takes a long time to make a representation or to formulate a representation? Now, I think there's significant difficulties. You referred to risk. My view is with constitutions you don't take risks because they're going to be there pretty well forever and they're very important. So my view would be that you would eliminate that risk.
If I could tease the examples of that out, let's start with the definition of the executive. How do you define the executive, from cabinet down to public servants in the Department of Lighthouses? How do you define it and how big is it?
I think that's pretty easy. It's everyone. So realistically, it goes from cabinet down to the lighthouse keeper's bulb polisher. All of those things are part of the executive government. And therefore, when you simply use a compendious phrase like executive government, the assumption has to be it's everybody. So, for example, there's been obviously some controversy about Reserve Bank interest rates. On the face of it, a Reserve Bank interest rate is done obviously by the Reserve Bank, and the Reserve Bank is part of executive government. So you'd have to have a pretty sophisticated argument to say that it was not justiciable if the rest of these things are justiciable. And I know the Prime Minister has said he doesn't want that to be justiciable. He doesn't want it to be subject to the voice. But again, you go back to the scope. The scope of the voice effectively allows it to make representations relating to Aboriginal people. So when you put the huge definition of executive government with the huge definition of scope, you really are in a position where the voice potentially may make almost any representation on almost any subject to almost any part of government.
And I'd like to refer to the explanatory memorandum, and there's the Minister's speech as well. And In any dispute about the ambit of power in section 129(2), would you agree that the High Court would adopt an interpretation that enabled the power to achieve its intended purpose? Would you agree with that?
Yes. So, I mean, I know there's some discussion about maybe the second reading speech or the explanatory memorandum can effectively confine executive governmental scope here. And I know that, you know, Professor Toomey, who I meet often walking between Mosman Bay and Crown Point, places great faith in explanatory memoranda and second reading speeches. I guess I'd say three things probably. One is the High Court's only going to look at that if the provision is ambiguous, and the High Court doesn't usually like saying a provision is ambiguous, and maybe these provisions are entirely unambiguous. The second thing, having looked at the second reading speech, I really don't see a lot that would confine the fundamental sense of the words there. And the third thing I'd say is, with constitutions, original intent or extrinsic says do not have a very happy history. So with the Constitution itself, we have 7,000 words of convention debate saying what the Founding Fathers meant. I know that because I read all 7,000 of them when I indexed them. And the truth is that until 1995, the High Court wouldn't even look at them. And still, I think, if I were to take a generalisation, the High Court looks at them for the purpose of confirming what they already want to say. So I don't have that same confidence.
Earlier you agreed, or you told us, that the executive is quite expansive and it's everyone. Given that, would you agree that there are potentially thousands of decisions made daily or weekly from the executive?
Yes, of course.
And would you agree that one of the purposes of the voice, which is in the explanatory memorandum, is to enable the voice to influence government decisions? And I'll put a proposition to you. That purpose would be defeated if the executive was free to make irreversible decisions without giving the voice a prior opportunity to make a representation and without giving the voice reasonable information about the issue so that a meaningful representation could be made. What do you say to that?
Well, that would be logical if you had regard to the normal principles of statutory interpretation. So, of course, it's like being consulted. If you're going to be consulted, you have to know what the proposition is. You have to be able to comment on the proposition. You have to have that comment considered. And, yes, there would be an implication that you would have to have some capacity to do it, which would mean time. So on the face of it, I think these words, they're just not grafted well enough. They are too wide.
And we'll get to that. And can we put it this way, and you can agree or disagree with me, that if there is a right to make a representation, and that's what the words say, that right cannot exist if the voice doesn't know that there's a representation to be made about. Would you agree with that?
Yes, that normally would be the position. So I taught advanced administrative law. And if you had, the Mosman Council has to give someone the right to make a representation, but they don't know they're going to build a dog pound on your block, and they tell you with 1 day notice, you've got a problem.
And can we tease this out? So, hypothetically, and there'll be different views about what a future High Court would do, if the words remain unchanged and a future High Court was of that view, could this scenario occur that in order to effect that right, the High Court says that there is an obligation on the executive to do three things? One, provide prior notice of proposed decisions, provide information about those proposed decisions, and then to take representations from the voice. And no one is saying that's as a veto, or you have to agree with it, but just in terms of those three propositions, what do you say to those?
I think that's entirely possible. I mean, lawyers would call that procedural ultra vires. If you didn't follow a particular procedure, then someone could go to a court to effectively stop you. Now, yes, I think that's right. Now, you could argue that particular types of decision are non-justiciable, maybe things in relation to defence or the Governor-General, but on the face of the words, executive government is absolutely general, and the High Court normally gives words their full meaning. So, yes.
Yeah. Thank you, Professor Craven. I would like to now go to the submissions by Professor Toomey and the papers by former Chief Justice French, because they have very helpfully addressed this issue, and we will hear from them later with a right of reply. So Professor Toomey and Robert French say that 129.2 does not contain an implied obligation to take the representations into account. And there's a few different reasons. I'd like to go to one that Toomey and French, excuse me for using surnames, agree, and then another that is just former Chief Justice French, or the other way around. So I'll start with the one that they both seem to make, which is that it would be impossible to apply that implication to all executive decision-making because it would be impractical. And what do you say to that argument?
Well, if that's right, then we shouldn't just say executive government. I mean, if we're going to carve out exceptions, then we should carve them out. And the problem is we're probably not going to be able to carve them out by later legislation, because later legislation is going to have to comply with the words of the section. And the section says executive government, so it means executive government. I just don't know by what process a High Court would do that, particularly because I think that would classically be judicial activism. So you have a High Court that's basically cutting and pasting, you can do this, you can do that, that bit doesn't count. I think not only is it probably unlikely the High Court would do that, but if it did, it would create the very problem that the voice was designed to prevent, which was decision by judicial decree.
And again, Professors Toomey and former Chief Justice French will explain their submissions in their own words. But accepting that argument is sound and it has been well put, and no reason to deny it isn't, the High Court often hears conflicting arguments that are sound and well put, and that is why we often get many split decisions or unexpected decisions. Can I put two counters to the submissions put by Professor Toomey and get your opinion on them? An argument against that submission will be that the implied obligations on the executive would apply to justiciable and non-justiciable matters, and there is no barrier to accepting the implication because the Constitution already contains express powers and restrictions that have been held to be non-justiciable, and an example is Section 53. So I'll go to a second argument, but what do you say to that as a counter? And Section 53 is the powers of the House in respect of legislation.
It's really a question of what you incorporate into the concept of executive government. You know, do you incorporate all sorts of, traditional restrictions and exemptions? My problem is that I think what executive government means is executive government. It's relatively clear on the face of it. And I mean, if I were the High Court, and you think of the range of decisions that can affect Indigenous people, some of which are going to be decisions under prerogative, some of which are going to be high prerogative decisions regardless. Given the discussion around the voice and given the views of Indigenous leaders and all of those sorts of things, I think everything confirms that the intention behind it is that it will apply generally. And I think, again, if the court were to run around carving bits out by reference to common law notions of non-justiciability, again, you have an extraordinary level of judicial action. Take the sort of argument I've often used. Say you're going to deploy submarines off Darwin. Obviously, you can't do it off Alice Springs. So you're going to have submarines in close proximity to a place that has lots and lots of Indigenous people. So if an unnamed nation ever chooses to strike against those submarines, there will be a disproportionate number of Indigenous people killed. Why isn't that caught? And if the High Court starts carving it out, I would have thought that Indigenous people would say, who are you kidding? This is one of the most fundamental executive decisions that can ever happen. It's absolutely tied to us. And you're saying that you've carved it out by reference to something that isn't even in the section? I find that problematic, and I'd come back to what we were talking about at the start. with constitutions, you don't want risk because the risk is perennial and the risk is big. So if Anne and I are having this sort of argument, I have the greatest respect for Anne and I'll claim she has the greatest respect for me, wouldn't
She's
it
smiling.
be better? Yeah. She's smiling with affection.
Yeah.
Wouldn't that be better off dealt with before we actually cement the words in the Constitution?
Well, can I put something to you? We heard very powerful evidence about the importance and the benefits of the voice to the executive. Do you agree that you can have a voice to the executive but have it legislated? So if there are unintended consequences, the Parliament can fix it.
You could do that. Yes, of course, the Commonwealth has power to do that. The problem would be, from the position of people like me, that the constitutional entrenchment and status of the voice is vital, if you like, to its payload. So the difficulty, and yes, you could do it, and people have said you should do it first and then go a constitution. But I think the debate really is about constitutional recognition. And to me, constitutional recognition is fundamentally important, simply because Indigenous people are fundamentally important themselves, and the test for putting something in the Constitution is that it's fundamentally important. So as I often say, if we've got lighthouses, beacons and buoys, surely we can put Indigenous people in.
And just to be clear on my question, I wasn't saying legislate the Parliament. I was voice to Parliament. I was saying the narrow part of legislating a voice to the executive. I was carving that out.
Yes, sorry. So yes, I think that's absolutely right. So what you could do that would avoid the problem of representations to executive government would be to confine the general right that's currently there at the moment and allow the Parliament to deal with what class of executive actions the voice could make representations on. So that would put the power to define the matter in the hands of the democratically elected Parliament. It would mean that Parliament could say these decisions but not that. We're not doing nuclear submarines, we're not having the Reserve Bank, we are going to have native title, whatever. Yes, that would make a lot of sense. And Attorney General Dreyfus, in fact, proposed that in the past.
And one follow-up, this is important, it's the final, this is at the heart of our task, so I would hope we can extend time on this. The explanatory memorandum says that in the final, second last paragraph, the constitutional amendment confers no power on the voice to prevent, delay or veto decisions. And then the final paragraph says, the amendment would not oblige the Parliament or the executive government to consult the voice, and then I'm paraphrasing, before making a decision or taking any other action. If that is the intent of the government and the minister, and there is a risk that that is now not reflected in the wording, do you see any reason why the wording cannot be amended to reflect that intent?
None. I don't think there's any legal reason. I think you have to be precise. So we should always remember Section 92, trade shall be absolutely free, which Sir George Reid says a little bit of layman's language that makes total sense of the Constitution. There have been more cases on Section 92 than any other section. So with constitutions, you are specific and you remove doubt.
Thank you, Chair.
Thank you.
Thank you, Mr.